Bienvenidos, and I won't even repeat the other ones because I may not pronounce them well. But thank you for coming. I'm David Duran, and I'm the Equal Opportunity Officer for the Department of Workforce Development and the Division of Employment and Training. I'm joined here with my colleague, Ernestine Moss. And Ernestine Moss is the Equal Opportunity Officer for the Division of Children and Families. So she was doing a presentation this morning to Human Services staff. So she certainly will be helping me this afternoon as well. Just to get an idea, how many of you actually just do WIOA? Everybody? Okay. Are there folks that also operate food share programs, FSET, W-2, and so forth? Okay, that gives me kind of a context in terms of what what may apply or may not apply to you as well. But if you're administering WIOA, most of this will apply. There may be some slight changes or differences now in terms of regulations and so forth, but pretty much all of the laws are cross-cutting. They cut across not just a lot of the programs, federal programs, but also the federal agencies. So welcome. I hope that we have a lot packed in this 4 hours. I'll try certainly to get you out of here before, but I also want to give you the opportunity to ask questions. This is probably your opportunity right now to ask questions and probably get more guidance. If I cover something that seems to be a little confusing or fuzzy, stop me, ask for clarification and so forth, and we'll take it from there as well. So I'm not going to follow us very, very rigidly because I know this stuff is pretty dry. And if I don't want to put you to sleep or see your eyes glazed over, because I'm not going to cover cases or anything, but we will talk a little bit about in terms of some of the things that you really need to think about when you go back and you're developing, administering, involved in whatever activities you're involved in, and how all this applies to you and to your agency as well as your employees that you may supervise or you may be responsible for. The agenda, I think you already have a copy of the agenda, a hard copy of the agenda. So we're going to try to cover all of this cover all of these topics during this particular time. But before we get on with the presentation, what I want you to do is take a few minutes and pull out your pretest. And what basically kind of gives us an idea in terms of what is your knowledge at this point. Believe me, we're not going to test it. I mean, we're not going to get your scores, or this is not going to go on your record or anything. So at the end of the presentation or the training, we'll go back and go over some of the answers and see how you did. So why don't you take a few minutes. Are you done? Or a little bit more time? No? Okay. We'll put it aside, and then we'll come back to it at the end of the training, and we'll go over some of the answers and see how you did. I think there was a few trick questions in there. Okay. Our training objectives. What we're going to try to do here is go over some of the civil rights laws that apply to recipients of federal financial assistance. Now, recipients of federal financial assistance includes what we refer to as our primary funded recipients, which includes counties, it includes workforce development boards, and then their subrecipients, which includes anybody that they contract with, whether it be a training agency or a private non-for-profit organization, or whether it's a county subcontracting with certain other agencies to deliver services or provide different functions. We're going to cover a little bit of discrimination, which is prohibited by some of the federal civil rights laws when federal financial assistance is extended. We're going to try to clarify what is the funded entity's obligation and roles and responsibilities, specifically as it relates to the executive director, chief executive officer, whatever you want to call them, agency heads. What are their specific responsibilities? What is the responsibility of equal opportunity officers? And in some instances, they're also referred to as equal opportunity coordinators. Some entities do designate a limited English proficiency coordinator depending on the size of the organization. So that it may apply to you or may not necessarily apply to you depending on what agency you're involved in. And the reason for that is because oftentimes we allow the equal opportunity officer to serve also a dual function as equal opportunity officer, again, depending on the size of the organization. That is certainly permissible. And then we'll talk a little bit about the job center complaint system, the coordinator, kind of clarify what is the roles and so far. And the reason for that is because under WIA, you not only have non-discrimination complaints, but you also have grievances that participants can file. And then there's also program types of complaints. And then there's also Wagner-Peiser that requires job services, and especially one-stop centers, to have at least a person designated to take complaints, especially when you have a one-stop center where you have numerous partners operating within the center. Anybody can file a complaint about anything. There's program complaints that need to be filed because of grievances as it relates to the programs, but anybody can file a complaint about, potholes in the parking lot and so forth. And so, or it could be, a specific agency, or they have a problem with a specific individual within an agency that is in your job center. Those things need to be resolved through whatever processes are developed by that particular agency. So we'll talk a little bit about that as well, try to give you some clarity on that. And then your complaint steps, processes under WIA. We'll touch a little bit in terms of HHS processes and USDA, and then we'll open it for some questions and answers. Okay. I'm going to cover some of the employment laws, not in detail because it is extensive. Just want to go over some of the things that if you are receiving federal financial assistance, you're also obligated to comply with employment laws, and that's pretty standard. Some of the laws that apply do include Title 7 of the Civil Rights Act of 1964. You're gonna hear us a lot talk about civil rights, the Civil Rights Act of 1967, and I'll explain a little bit later on why. The Civil Rights Act of 1991, and the Age Discrimination Act of 1967. Now, there is a Age Discrimination Act of 1975, which applies to program service delivery. This particular law applies specifically to employment in the employment section, so it's a little bit different than that it applies for service delivery. Touch a little bit in terms of the Americans with Disability Act. If you're an employer, you're definitely required to follow Title I of the ADA of 1990. That applies to employment. But it also covers service delivery, especially under Title II. And certain entities may be also covered under Title III, depending on whether you're considered a place of public accommodations. The Equal Pay Act, and then Section 188 of the Workforce Innovation and Opportunity Act also reinforces the fact that all of this laws apply when federal funding is received. And then a little bit on the Lilly Ledbetter Fair Act is also included. Now, this does not include every single other law that may apply, or even state law, like the Wisconsin Fair Employment Law. But if you're getting funding through the state, then also that kicks in as well. The Wisconsin Fair Employment Law and all of the other laws that apply here in the state of Wisconsin. So that's another tier of things, another level that you need to also kind of. English-only rules in an employment environment. Well, I wanted to bring this up as it relates to employment because I have heard of some complaints relative to some agencies putting in place English-only rules. Under Title II prohibits English-only rules in employment. English-only rules must be adopted for non-discriminatory reasons. An English rule may be used if it's needed to promote the safety and efficiency operation of employers or businesses. So it does allow for a very, very, I would say, probably exception to the rule. However, the rule has to be for the reasons of safety in the operations. You cannot, for example, allow your staff to harass individuals who are speaking, especially other employees within your organization, if they're speaking Spanish or Hmong, and if they're bilingual and they're hired for bilingual reasons, there cannot be any kind of rules that indicate that they can't speak their language, even one, because they have to do so with participants, but they also have to be allowed based under national origin discrimination, which is covered under Title VII. They're protected as well, so they can speak their language in the workplace. There have been some issues with that, with some entities, not necessarily entities, but certain staff harassing other bilingual staff because they speak a different language while they're working, while they're enjoying, while they're on break, and so forth. Any questions on that one? Some of the cross-cutting service delivery statutes includes, obviously, Section 188, that is specific to WIOA. That section requires that programs be administered in a non-discriminatory manner, that you provide equal access, equal opportunity. And it also incorporates all of the other civil rights laws that apply under service delivery, such as Title VI of the Civil Rights Act of 1964, Section 504 of the Rehabilitation Act of 1973. In some instances, the PERORA, which is the Personal Responsibility and Work Authorization or Work Opportunity Reconciliation Act of 1996. There were changes in there that applied to certain immigrants, for example, in service delivery. It prohibited certain immigrants from receiving services, especially undocumented immigrants, but it provided protections for those undocumented families to be able to apply for services on behalf of their U.S. citizen children. But nonetheless, we can't prevent them from coming and applying. They may not necessarily qualify, for example, for WIOA, because WIOA requires that the individual be a U.S. citizen, a legal permanent resident, a work authorized individual. But we need to make sure that we provide accessibility to them, especially W-2, for example, food share, medical assistance. Those are the kinds of services that are available to all U.S. citizens. The same thing with immigrants. We can't refer them to, for example, to employment, because that would be a violation of the immigration laws. We can't prevent them from them and coming in and using our resources, our resource room for our libraries to do job seeking and so far, as long as we're not making the referral to an employer. If they want to go do it, that's great. They want to go and apply to that particular employer. It's the liability of that employer to ensure that they're employing individuals who are authorized and who have proper documents in order to work. And I'll explain a little bit later in terms of the reasoning behind that. Section 508 of the Rehabilitation Act. Section 508 deals mostly with information and technology and ensuring that there's accessibility to individuals who are deaf, hard of hearing, as well as blind, and so forth. And it has very specific requirements as it relates to information that we use through, for example, the internet and so forth, ensuring that there's accessibility for those types of individuals. And then again, the Age Discrimination Act of 1975, which applies to on a service delivery basis. Title 9 of the Educational Amendments, and I'll talk a little bit about that and some of the implications now with the law extending the definition of sex. And we'll talk a little bit about that. Title 2, Subpart A of the Americans with Disability Act, which applies to governmental entities at the state level, but also at the local level. And then Title III, what I indicated, some agencies may be considered places of public accommodation. If you're a covered entity, then Title III also applies, which requires, it doesn't just require public, it requires private entities, restaurants, certain social service agencies, certain healthcare facilities and so forth, who are considered public accommodations, to also meet the ADA requirements, the accessibility requirements.
What about courthouses and parks?
Courthouses, municipalities are covered under Title II. Those are applicable to state as well as local, county as well as city governmental entities. And other agencies are covered if those entities end up subcontracting. And the whole rationale behind that is pretty much the theory of the requirements, the regulations, they follow the money as well. So wherever it is, with the exception, the beneficiary, it does not apply to the beneficiary or to the clients, for example. And I need to keep up with my...
You sure you don't want me to click that for you?
Oh, go back. Civil Rights Restoration Act of 1987. Well, let me tell you about that. When the Civil Rights Act of 1964 was enacted, initially Title VI did include a definition of program and activity. And some of you have heard me talk about when we apply the regulations, we look at whether you're able to provide equal access, equal opportunity, based on all your programs, based on the services that you're providing, as well as the activities that you're engaged in. And it was pretty clear that Congress intended the coverage of what is considered program, what is considered a service and activity to be broadly implemented across the board within an organization. Unfortunately, there was a case, Bob Jones University, where the court redefined program activity. Give you an example. Most universities get federal funding through different kinds of federal funding. Obviously, if you're doing research and you're applying to the NIH or any human services or CDC, or whether you're applying for other Department of Education, for example, financial aid for students. Financial aid for students is actually federal financial assistance. However, the Supreme Court in that particular case ruled that it did not apply, the definition of program and activity did not apply broadly enough to include the other departments within the university. It only applied to the student loan program, so it only applied to that particular office. And that definition was pretty much true for about 4 years until the Supreme Court, until the case of Grove City College, and in essence, what that particular case did, it pretty much prompted the Congress to actually modify or amend Title VI, or Title VI, excuse me, to reestablish the broad definition of what program activity included. And in fact, let me just quote you from Senate Bill 557, which was introduced. And it was introduced to overturn the Supreme Court 1984 decision in Grove City College versus Bell, and to restore the effectiveness and vitality of the 4 major civil rights statutes that includes Title IX, Title VI, Section 504, and the Age Discrimination Act of 1975. Those are the major 4 civil rights laws, and every single of those laws, every single regulation that applies to that defines program, services, and activities in the same fashion now. So what they did is they reinstituted the broad definition because Congress' intention was to apply it broadly. But in the Bob Jones case, the court narrowed its definition, and so Congress had to come back and reinstitute that. So what does that mean to you? Well, what it means to you is that if you define, what you do and how you do it, it applies very broadly to your organization. It applies agency-wide, everything that you do, both in delivering the program, in delivering your services, and in the activities that you're engaged in. What does that mean? Well, in some instances I've talked about during my site visits is that it isn't just the fact that, we have information that we provide, and if we don't provide it in an accessible manner to the protected groups, that may be, we may be engaging in some discrimination. And we'll talk a little bit about that in terms of what do I mean by that, and what is the extent of coverage of Title VI. But what I want you to understand here is that this particular definition and how it applies very broadly to you. So it applies to everything pretty much that you do and how you do it. Here's gender, sexual orientation, sexual identity. How many of you have started to see the new terminology pop up?
Nobody?
Gender identity, gender expression, transgender woman, transgender male. Pretty much it applies, it's starting to apply very, very much so in a service delivery perspective. Title IX of the Educational Amendments of 1972 has been modified and now defines sex beyond just gender, male, female, but it also includes persons who have different sexual orientation, that are transgender, both male and female. So as we move forward, we're going to have to adjust and add the definition of what is sex and who is protected under the new definition of sex. But it's much more so. It was reinforced, for example, with the passage of the Affordable Health Care Act, and specifically Section 1557, which is one of the first laws that now protects individuals on this particular basis, including all of the other categories that are protected now under Title VI, under the ADA, and so far those laws still apply, but it defines, specifically protects individuals, especially those in the healthcare industry that are engaging in the healthcare industry or in the marketplace looking for healthcare. It applies to insurers, for example, that are engaged in the marketplace. They can no longer discriminate on the basis of gender identity, sexual orientation, and so forth. And no, we've seen some insurance, do not allow this before did not allow this individuals to apply for healthcare coverage. But what does it mean? Well, it means that these laws are now evolving. They're cross-cutting. And everybody is defining sex now in those particular terms. When you look at it from an employment perspective, an employment and training perspective, you have to understand that, for example, Section 188 of the Workforce Investment for Innovation and Opportunity Act states very clearly that no individual shall be excluded from participation in, be denied the benefit of, be subjected to discrimination under, or denied employment in the administration or in the connection with any such program or activity based on race, color, religion, and sex. So when we're engaging in terms of employment and training services, we're seeing these folks coming in, or these individuals coming in and trying to access our services. We have to be cognizant that they're also protected, and that we're going to have to start modifying our terminology, our pronouns, to ensure that we're not discriminating against them, because somebody saying the wrong pronoun may get you in trouble. And so what we've done, and in fact I've added some additional resources that you may want to, and that'll be one of my suggestions in terms of training topics that you do cover with your staff when you go back and you do annual trainings or you do annual updates, all staff meetings, that you talk about these issues and that you bring people in that are knowledgeable, who talk about the differences and how to work with this particular groups. The same way that I would make recommendations that you include individuals, that you do cross-cultural communication training, that you do cultural sensitivity and awareness training. And I want to remind you, I want to keep away from the word cultural competency, okay? Because it's you never reach cultural competency. This is an evolving issue. New cultures are coming in, new communities are coming in. The best that you can do is provide enough cultural awareness of the folks that live within your area that you're serving or that you will be working with, and cultural sensitivity in terms of how do you provide the services to those folks. And never assume that you're competent. I'm not competent. by no means in other different cultures and so forth. So it's always an evolving and learning experience. But case laws since probably the 1960s, and I've also given you a handout on some of the case laws that have been changed, the courts have been hearing, where gender, sexual orientation, and so forth by case law, it is also being covered in terms of employment as well. You will note some of the landmark cases that, and you have all that information there. You may want to take a look and take a look at and see the evolution of how those decisions have been made and how we're inclusive now of gender identity and so forth. Are there any questions in terms of that? So yes, we will my suggestion would be is that when you start looking at your equal opportunity statements, when you start making changes to some of those posters and things of that nature, that you also give some consideration to maybe also including the definition of sex, or in parentheses, it includes the following types of individuals as well that are now covered. I know that we'll have to start doing that at the state level as well. We did, if some of you are familiar with the civil rights compliance requirements for the Department of Health Services, Department of Children and Families, and so forth, you'll see that we did add that, and especially Section 1557, added that back in the start of 2014. So, you know, we had already saw this coming, and we wanted to be a little bit proactive. Now it's also included in terms of employment, and now we want to make sure that you know and understand how it applies to also the WIA program and what we do. Whether it be WIA or Wagner-Peiser, doesn't matter. Those terms are going to, or those groups are going to be protected. I'm not going to go into any great detail in terms of regulations. You'll kill me if I do. Or throw tomatoes that hopefully you didn't bring. But here are some of the regulations that do apply. And again, 29 CFR Part 31 is the actual regulation that applies to the Department of Labor and Title VI. And for other programs, for example, that operate USDA types of services or human services, those regulations are going to be a little bit different. Each specific federal agency has their own Title VI regulations and very specific. So, you know, whenever you have issues or related to equal employment, equal opportunity, or civil rights issues, you want to take a look at your specific regulations and whether you're covered under those regulations, because again, there may be differences in terms of who's protected. As I mentioned before, under Human Services, 45 CFR Part 80, for example, the regulation covers race, color, national origin. Title VI. When you look at specifically what is covered under DOL, well, Section 188 includes rights, protection to U.S. citizens, legal permanent residents, refugees, work authorized, and so far, and that's backed up by Title VI, this specific regulation. Title 29 CFR Part 32 is the regulations that apply to disability. 29 CFR Part 33, enforcement of non-discrimination. Wait a minute. Also on the basis of disability and programs or activities conducted by the Department of Labor. 38 is the new regulation that implements the requirements for equal opportunity or your civil rights laws. What are the civil rights regulations that you have to comply with as it relates to a job center, WIA funded agency? The previous one was 29 CFR Part 38, but in July, because of the new law that went into effect and the changes, they needed to modify the regulations, and pretty much what they did is change the part from 37 to 38, and they changed the wording from WIA to WIOA. But pretty much this, the old regulations and the new regulations sort of mirror each other, except for those citations. 28 CFR Part 35 applies to state and local governments, and that's the Americans with Disability Act. And then other federal notices and registers. Other federal regulations that would apply is the guidances that come out from the Equal Employment Opportunity Commission as it relates to employment. Equal Employment Opportunity Commission management directive regarding affirmative action as well. Now, Executive Order 13360, was signed by the President in 2000, and that was included or was signed to protect individuals on the basis of race, sex, color, national origin, disability, religion, age, sexual orientation, and status as a parent in federally conducted education and training programs. So this executive order extends protection also to the status of parents, but also very specifically indicates sexual orientation. Now, Executive Order 13166, that order was signed into law, and I'll talk a little bit about that. It has to do more with access to individuals who are considered limited English proficient. And I'll cover a little bit more about that under the national origin discrimination slide. And then obviously Executive Order 11246 is for affirmative action requirements that requires employers or contractors, federal contractors who do business of 10,000 or over are required to take affirmative action, take affirmative steps to provide affirmative action, and requires them to also complete an affirmative action plan. Now, this is federal contractors and subcontractors, but it also includes construction contractors and their subcontractors. So how does that apply to you and us? Well, if you're a subcontractor of the state, 11246 may kick in. If you're getting a contract from the state of Wisconsin, there's a different statute that applies that may require you to complete an affirmative action plan. If you have a federal affirmative action plan and it's submitted to the state, that may be acceptable. If you have no federal funding, but you're only getting funding from the state, from one of the state agencies, there is a statute that kicks in, and that statute is 16.765, which requires all contractors and their subcontractors, when you get a state contract, that you have to complete an affirmative action plan and submit it to the state agency who is contracting with you. Or you could submit it to the Department of Administration, and they would enter that information in what is called a vendor net directory, which can be accessed by any state agency, so that if you're also doing business with with DHS and then also DWD, DWD could take a look at it, and if you already have a plan that's been approved, we wouldn't be requesting for a copy of that plan. The law says that you have to submit your affirmative action plan within 15 working days from the day that you sign your contract. And you folks forget about that. The good thing is that municipalities, counties and municipalities are exempted from having to file an affirmative action plan with the state agency.
So David, so counties and municipalities, so under WIOA, just as under WIA, the counties are ultimately responsible for our programs. They're responsible to appoint the workforce board, and they are responsible financially.
Right.
Does that mean then that WIOA would be exempt from this Executive Order 11246 making an affirmative action plan?
You're an entity of your own, though, right?
We are well, we exist by virtue of the counties creating a consortium and appointing and overseeing our boards and assuming fiscal responsibility. Without the counties, we do not exist.
Right.
I think this is a more recent
No.
court case that was dealt with that talks about that. But for our purposes, every agency has to definitely do the civil rights compliance. But with the affirmative action, I guess I've never been asked by what we consider a private entity if they have to adhere to that based on the fact that they have the state have oversight over it.
The answer to that is you're considered a quasi-governmental entity. And so from that perspective, we have not asked the workforce development boards to submit an affirmative action plan as part of that contract that you get from DET. Now, there's always exceptions here. There's always exceptions and so forth. That does not take the responsibility of you from ensuring that whoever you contract with, okay, that they have an affirmative action plan, because it also applies to them. It applies to them as Executive Order 11246. That applies to federal subcontractors. It applies to nonprofit organizations. It may apply to certain private agencies who get contracts and so forth. And it also applies to their subcontractors when they subcontract down the line. So in theory, okay, you as a quasi-governmental entity may not have to complete that plan. You still have to take affirmative action. You're still bound by employment laws and so forth. It's just the plan you just don't have to submit.
And along those lines, David, is there a minimum size that organization has to be before they're required to have a formal written plan?
Yes.
Obviously, we have to follow the
right.
civil rights laws, but in terms of having a formal written plan, is there a minimum size?
For if you're only dealing with a state contract, state funding, state contract, the statute states that if you have 50 employees or more and receive more than $50,000 in funding or contracts, that's the threshold that triggers that requirement. Now, mind you that if you actually look at Section 504, Section 504 also requires affirmative action, especially of entities that have less than 15 employees, I believe. And that triggers an affirmative action plan. That's up and beyond the Executive Order 11246. So you're looking at different laws and how affirmative action requirements are triggered at the state level and at the federal level. Was there a question over here? Okay. Make sense?
So the 50 is a state requirement.
Right. And in fact, we used, when we started collaborating all three state agencies, we used that trigger also to trigger a civil rights compliance plan. Because we felt that, when you're starting to get about that large and so far, civil rights should be a little bit more heightened, and we want you to really take a look at and develop a plan and methods and services or methods of how you're going to implement the civil rights requirements. We still require, for example, DWD, DET requires that you file an assurance statement that you're going to comply with all this stuff, all of these laws, and so forth. For DHS, DCF, and quite frankly, we could use the letter of assurance that most counties have submitted, and I think Doug is familiar with those because, you know, Kenosha, Racine counties operate the programs. Well, Walworth County is contracts to a subcontractor, a private entity, but nonetheless, wait a minute. It does, and I lost my thought.
With regards to the affirmative action.
If we have to submit our civil rights plan every 3 years, and we are required to submit our affirmative action with that, does affirmative action still need to be done annually?
No.
Affirmative action is separate now. We used to combine them in an effort to save you a lot of labor and trouble, but now we do the civil rights compliance separate from the affirmative action plan. And
But you wouldn't have to submit a new plan.
But we have to have one on file.
You have to have one on file.
We still, as a company, would have to do it annually, but we don't have to submit it to the state once or every 3 years?
If you have one submitted, you can continue to apply and get grants with whatever state agency you're getting funding for the 3 years. That, once your plan is approved, it's approved for 3 years, you don't need to resubmit another one. If a state agency asks you for your affirmative action plan, all you can do is send them your letter of approval, or not letter of approval, but your letter of acknowledgement that you do have a plan in place.
If we do our affirmative action every 3 years, as far as affirmative action and civil rights is separate, are we still compliant under affirmative action?
she's
Yes.
asking about affirmative action
Right.
because the civil rights compliance, the affirmative action has to be on the VINET and all that, so.
The affirmative action plan is good for 3 years. The civil rights compliance plan is good for 4 years. But again, you know, as long as you have an affirmative action plan in place, you can continue to do business with the state agency. Now, that may differ if you're an agency that are getting federal contracts directly from a federal agency, those procedures may be different. And then the requirements of the federal contract, the Office of Federal Contract Compliance would kick in as well. So, you know, whether you're doing direct federal, whether you're doing state, or whether you're doing, you know, just, you know, you're still going to be covered somehow in some ways, and ensuring just exactly what needs to be done. If you're a federal agent, if you're getting federal funding directly from the federal government, and you've submitted an affirmative action plan to the federal government, the Federal Office of Contract Compliance, you could submit that plan to the state of Wisconsin, and the state would accept that particular plan and would probably, you know, would be okay. I mean, you wouldn't have to do a different plan just to comply.
We were confused because the affirmative action guidelines say that they have to be done annually, but under the civil rights compliance, it says we have to spend every 3 years. So we don't have any direct federal funding, so we want to make sure that by only doing it 3 years, we're still in compliance.
Which instructions were you reading?
It was under the federal affirmative action. I mean, it's under the affirmative action plan.
Okay, it must be the Federal Office of Contract Compliance requirements in the regulations, because the state instructions does allow you to submit it, and if it's approved for 3 years. And those are the instructions that direct from the Wisconsin Office of Contract Compliance, the Department of Administration. Yeah. Good.
And if you're with an agency, you should know who your person is that you should contact, and just follow whatever those directions are, because if they change, they should be out there. And like you said, you're reading the civil rights compliance. So whatever your contract I shouldn't say that, because some people got confused when the new contracts were issued as to whether or not they needed to fill out another civil rights compliance LOA. And you don't, as long as you're getting the contract within the period of that civil rights compliance letter of assurance. So you just have to watch which one you're responding to. If it's affirmative action, you have to know if it's the state or the federal. And with the civil rights, everybody that get a federal financial assistance have to complete that civil rights compliance letter of assurance. But they do not have to complete a plan unless they are over 50 employees and receive over $50,000. You complete it, but you keep it on file. You don't send it in to us. You complete it if you're over 50 and 50, but you do not submit that to us. Thank you.
Very good. Other applicable regulations that may apply, they certainly would not apply, this regulations wouldn't apply to, for example, the Workforce Development Board, unless they were getting money specifically through DHS or DCF or HHS directly. But oops, here we go. These are HHS regulations that applied on a human services level. Anybody that gets funding through, and as you can see, Title VI, just different citation, Section 504, different citation, and then there's different sections of different laws that also apply. So you're really dealing with the same statutes. Pretty much the regulations kind of mirror themselves, except for maybe some wording. But they're all cross-cutting. They all apply to all. They all apply to federal agencies, as well as to those that they subcontract and so far. Title II of the Americans with Disability Act and the various citations of the, and then also Section 508 is included in there of the Rehabilitation Act. Here we go. It's been a while, folks. I think I need to get coordinated between my looking over here and clicking.
Want me to help you out?
Hold on, that's fine. I just need to remind myself that I got to click. Here's some also other programs, for example, block grants, specific block grants that are issued under HHS to the various states, whether it be the Community Services Block Grant, the Substance Abuse Block Grant, the Family Violence Prevention Block Grant, Public Health Service programs, and so forth. All of this different block grants and different sections also reiterate the four basic statutes. They're included. It applies. It applies all the way across the board. Here's some of the remaining ones. USDA, F&S. Well, if you were administering food share, for example, or food FSET, these are the regulations that you would be looking for if it deals specifically with your USDA program, funded program. And again, look at the various different citations, but if you take a look at the different regulations, they're going to pretty much mirror themselves as well. Except that USDA does have other protected categories, other protected groups, such as familiar, different other groups that are protected because of WIC, and so far. So there's going to be a little bit difference in terms of the protected groups under USDA. Nope, did I go back? And pretty much they all mirror each other. They reference each other back and forth. All right. What is the civil rights? Well, here there's a general definition of what a civil rights is. So an example. There are other examples with which accurately define the terms as well, as numerous additional examples would include. But pretty much, civil rights include freedom of speech, press, and assembly, the right to vote, freedom from involuntary servitude, including human trafficking, for example, and the right to equality in public places. The picture of Charles Hamilton Houston. How many of you know anything about Charles Hamilton Houston? Yeah?
No historians, huh?
He is referred to as the Moses of the journey that led to Brown and beyond. Actually, Mr. Charles Hamilton Houston, a law professor at Harvard or at Howard University Law School, actually trained attorneys, and attorneys like the late great United States Supreme Court Justice Thurgood Marshall, who advanced along with a team of lawyers the case that provided the basis for overturning Plessy versus Ferguson and given us Brown versus the Board of Education, Topeka, Kansas case, in which the United States Supreme Court reversed separate but equal doctrine held in Plessy. So, civil rights, you definitely want to cover what are civil rights so that people understand what civil rights are. Discrimination. It is not membership in a particular group or class that determines when discrimination has occurred, but the denial or interference of a right because of that membership that constitutes discrimination. Now, how is illegal discrimination defined? Many people use the term discrimination to mean any kind of negative or perceived unfair treatment. In fact, the term of discrimination and civil rights have a very specific meaning. In most cases, any kind of negative or perceived unfair treatment is likely not the type of discrimination that we're going to talk about here. And then again, the definition that you see is in the slide provides just the basic definition of illegal discrimination. But again, we want to make sure that people understand the differences between what is really discrimination versus a negative type of a complaint, or that may not necessarily be discrimination. Title VI of the Civil Rights Act prohibits discrimination on the basis of race, color, and national origin under any program or activity. And again, we repeat program and activity. And you need to look at it from a very broad perspective and how it applies, that receives federal financial assistance. The 88th Congress passed the Civil Rights Act of 1964 to enforce the constitutional rights to vote It conferred jurisdiction over the district courts of the United States to provide injunctive relief against discrimination in public accommodations. It also authorized the Attorney General to institute suits to protect constitutional rights of in public facilities and in public education. It also extended the Commission on Civil Rights, and it also included, actually, Title VI, which prevents discrimination in federally assisted programs. It also was passed to establish the Commission on Equal Employment Opportunity and for other purposes. Today, the major focus of our discussion is going to be on Title VI and its regulations and how that applies. The landmark Civil Rights Act of 1964, signed by President Lyndon B. Johnson on July 2, 1964, was a product of a growing demand in the early 1960s for the federal government to launch a nationwide offense against racial discrimination. In calling for the enactment, President John F. Kennedy identified simple justice as the justification for Title VII or Title VI. And I want to quote exactly what President Kennedy indicated. He indicated that simple justice requires that public funds to which all taxpayers of all races contribute not be spent on in any fashion which encourages, entrenches, subsidizes, or results in racial discrimination. Direct discrimination by federal, state, and local governments are prohibited by the Constitution. But indirect discrimination through the use of federal funds is just as invidious, and it should not be necessary to resort to the courts to prevent each individual violation. So it provides simple justice, simple processes to try to address discrimination without having to resort to the courts. Title VI regulations also authorize and directs federal agencies to enact rules, regulations, or orders of general applicability to achieve the statute's objectives. Federal agencies, regulations prohibit use or using criteria or methods of administration that have the effect of discrimination against protected groups based on race, color, or national origin. But it isn't just specific to Title VI. If you look at some of the other regulations and some of the other statutes also include, and in fact, all of the Title VI regulations in all of the federal agencies also prohibit any use of criteria or method of administration. And we'll talk a little bit about more in terms of that. But the Civil Rights Act of 1964 compelled U.S. HHS, USDA, DOL to develop rules, regulations as part of Title VI to ensure consistent implementation of the law. In mandating that all 30 or so federal agencies adopt regulations which prohibit the use of criteria and methods of administration that have the results of discrimination against protected classes, groups would, or based on race, color, and national origin. There is a general applicability of Title VI of all federal assistance, regardless of which federal agency provides the assistance. It applies to money paid, property transferred before the effective date of the regulations, the use of any assistance by any individual who is the ultimate beneficiary under any such program or any employment practices under any such program or any employer, employment agency, or labor organization except to the extent described in section, and in this particular citation is the 45 CFR Part 80.3. But you will also see that specific wording and that specific citation also in the regulations under the Department of Labor. And you probably will see also. What this means is that, to give you an example, human services programs, it does not apply to employment, for example, under an HHS program. However, it does provide, it does include, for example, the Workforce Investment Act, because you're dealing with employment and training programs. So it does apply in that sense, that Title VI could encompass the activities that are involved with employment, such as on-the-job training. If an employer would discriminate against a participant that's on the job, is a participant of WIOA, it could come into my preview. I would have jurisdiction to maybe investigate a discrimination complaint based on it in an employment situation. That would probably be the only time when I would have jurisdiction. Otherwise, if it's just a participant that we referred to an employer, they hired them, and then later on they were discriminated against, they certainly can apply and file a discrimination complaint, whether the EEOC or the Division of Equal Rights. And in fact, we would encourage them to go through that route, because those are the two enforcement agencies that have jurisdiction over employment statutes. The only time that I would have that kind of a coverage would involve if that participant was still involved in employment and training services that were being either sponsored by WIA. I'm not sure in what context would DCF have jurisdiction over that. I can't think of any employment program where they would be funding, unless it would be a senior employment program under Title V, but I think those come through the Department of Health and Human Services. That citation might apply in that particular
if the monies are given specifically for employment, maybe in certain specific placements and stuff like that. If it's specific for employment-related activity, then, and that money is coming from Health and Human Services, it could apply. But in most cases, we're looking at service delivery and not Title VII, because in the W-2, when people get hired and stuff, they are looking to go ahead and be a permanent employee for that employer. And so if they have issues, we encourage them to go to the DWD or the Commission, Equal Employment Opportunities Commission.
Yeah, but if it was being subsidized through us, then that may apply. The U.S. Supreme Court has upheld that the federal agencies are within their right to include and prohibit practices which have a desperate impact on particular groups. So it's those methods of administration that oftentimes have that adverse impact. So even the federal courts have sort of conferred that, those regulations are proper. Intentional discrimination, and also, often it is referred to as desperate treatment. There are two theories or concepts involved in discrimination, which is specifically prohibited under Title VI. Neither mutually exclusive are used as basis for analyzing discrimination claims under federal and state statutes. These theories are desperate treatment and desperate impact. Desperate treatment happens when a protected class member is treated differently than a member of the majority or predominant population. To prove intentional discrimination, one must show that a challenge action was motivated by an intent to discriminate. This requires a a showing that not only was the decision maker aware of the complainant's race, color, national origin, but that they also took adverse action based upon that knowledge or information. However, the record need not contain evidence of bad faith, ill will, or any evil motives on the part of the recipient. So there's still possibilities that we could find discrimination. If it's obviously if it's not intentional, then could it be unintentional discrimination? Which is the next theory. The second theory or concept is referred to disparate impact. Disparate impact is a statistical measure where a significant number of cases or instances are used to determine whether the rate in which members of legally protected groups are treated differently from members of the majority or predominant population. It goes directly to your neutral policies. The unintentional discrimination or those neutral policies or practices that disproportionately have the effect on individuals of a protected group. Very, very clearly, a couple of the points, the limited English proficiency population. When we do not develop materials, we do not provide interpreters, we do not provide accessibility to certain individuals, and our policies support that, our practices or our methods of providing the services are having that particular adverse impact, that could be discrimination as well. And so it isn't just that you have to worry about intentional discrimination, but it is the unintentional discrimination that we tend to get into trouble more often than not. And it's not because it's our intention. It's just that we're too darn busy, or we are wearing too many hats, or somebody is not checking that those policies and procedures are actually in effect working. And it could happen that you do have all those policies, procedures, and so forth, but that somebody didn't read them, and somebody didn't know how to apply those services or those methods and procedures to provide the services. National origin discrimination, services in languages other than English. Title VI bars utilization of criteria and methods of administration that have the effect of defeating or substantially impairing accomplishment of program objectives with respect to individuals of a particular race, color, or national origin. Now, universal regulatory language incorporates disparate impact standards into Title VI. So again, and across the board, every federal agency that has to have Title VI regulations, it's built into that language as well. So it doesn't matter what funding source you're dealing with. As stated in Title VI, no individual shall be discriminated on the basis of on the basis of race, color, national origin. Persons who are considered LEP are specifically covered under national origin discrimination. Well, LEP individuals have been protected by Title VI since when? 1964, when the law was passed. That's something over 50 years ago. We neglect, in some instances, refuse to abide by what we agreed to do when we accepted federal dollars. And that has been true pretty much. We tend to forget how this applies and oftentimes do not provide the necessary services. As a consequence, over the years, in August of 2000, President Clinton signed Executive Order 13166 to further clarify and confirm the government's commitment to Title VI and to ensure that LEP individuals are afforded full and equal protection in programs, services, and activities in a meaningful manner when federal dollars is extended to the public sector, state, local governments, or to public for-profit and nonprofit sectors. Now, HHS, USDA, DOL, LEP guidances further clarify what recipients of federal assistance must do in order to ensure that LEP individuals are provided full and meaningful access to all programs, services, and activities. And I'm going to keep repeating, programs, services, and activities, because the extent of the coverage. This LEP guidance is applied to all entities receiving federal financial assistance regardless of the source. Entities receiving federal assistance from other federal agencies other than HHS, USDA, DOL must follow the guidance published by those other federal agencies. The last time that I went to look at lep.gov, which provides the executive order and then all of the the 30 different federal agencies that must develop their own guidance to implement their Title VI regulations. Pretty much a lot of the agencies have developed guidance specific to their funded recipients. So you can always go to lep.gov, and if you're looking for the Department of Transportation's guidance as it relates to LEP, you'll find it right there as well. And I'm going to cover a little bit in terms of what is required under those guidance in terms of providing meaningful access and so forth in a little bit.
All right, so David, a couple years ago, actually more than a couple, I had a plant closing in Green Bay, and we truly had, I can't give you the exact number, but it was like 10 or 12 different languages being spoken in that facility. So what's my responsibility in terms of providing dislocated worker services under WIOA in a situation? Do I have to bring in translators for everybody, for each of those 12 language groups?
The answer is you have options.
Okay.
Yes, you could bring face-to-face interpreters. You could set up a language line connection to the various languages depending on how many individuals you have, whether and we'll go over some of the 4 factors that you may want to consider. But there are options. What the law says is you have to provide, or the law, Title VI says you have to provide equal access, equal opportunity. The guidance says you have to provide meaningful communication, accurate and meaningful communication in order to comply with Title VI. So it requires you to provide accurate and meaningful communication with those individuals. When you're talking about oral language assistance, you're talking about providing oral language assistance to anybody with any LEP language group. If you have one person that speaks a foreign language that is not recognized around here, we're still, and they're applying for services, they're eligible for services, we are required to provide access to that individual. That's why we require that you have either a language line or that you have bilingual staff. At certain thresholds, you're going to have to translate vital documents because the proportion of LEP groups are represented in your area. But definitely, you have options of how you can provide that meaningful access. And we have to provide it because it's one of those activities you're engaged in using federal funding. And so whether it be at the paper mill or whether it be at the foundry or whatnot that is closing, we have to provide that access as well. That's a question that was asked of me also from our state staff. What is our obligation to provide access to services? If we're engaging those individuals, we're going and providing that services to them, then it becomes our responsibility as a state. If it's your responsibility to provide, you're providing those services because of contract or because you're required by contract, you also have to provide that services at your particular level.
And so that would be like applications and other important information that you may develop at the counties. Some of your applications and notices are actually, if you're in the human services, are done by the state. So we have identified a large number of We've
53.
identified over 50-something, but we have a large poster that you all should have in your agencies, notifying all the various population that we are aware of in the state of Wisconsin, that they have the right to ask for that information, vital information, in a language that they understand. So, sometimes it might not be so extensive, and they won't ask you to give it to them in writing. But if they should, you should be willing to do that if that's a vital document that they have to respond to. Anything they have to sign their name to and stuff like that.
Okay. There was another question, Kim?
As far as what Jim was saying, even if when we do our rapid responses, we're just going in and providing the information and what services are available. So at that point, they're not in our program. You're just there, saying here's what we can help you with. Even then, we should still be talking with the employer.
Well, yes. In fact, I'd suggest that once you're notified and you're going to ask the employer, what is your workforce like? Do you have anybody that speaks different languages and so forth? And you're going to find them because you got Spanish speakers, you got speakers, different kinds of speakers. So, and the reason is that we're the ones that are being paid to do this. It is the activity that we're engaged in. When we're delivering services in our facilities, it's still our responsibility to ensure that those services are provided there. But anytime that we go out, if we go out, for example, for an appointment at somebody's private home, and they happen to be LEP, then we need to make sure that we're prepared to provide that interpreter in order to be able, and especially if they're limited English proficient. And limited English proficient means that, just because they know English and they may be able to converse in a limited way, doesn't necessarily mean that they have an understanding of the language or understand the technical or legal terminology that we tend to use or that we require them to know and understand and sign, based on their rights and so forth. So yeah, it becomes our responsibility how you provide that meaningful access, meaningful communication, and accurate communication. Again, you have to assess what is it that works best and may be cost effective.
Yeah, and I apologize that Kim and I were chatting here.
No, that's fine.
We were clarifying something. The situation that occurred is we had a partial plant closing, and we were sending people in on the rapid response pre-meeting with the employer. They indicated that English is the preferred language. You don't have to worry about other languages. We specifically asked the question. When we got there, we found out that there were a number of Hispanic-speaking individuals. We weren't equipped at that meeting, but then we learned something for future contacts and future meetings that we would be better prepared.
All right.
Yeah.
It was a little disappointing, I guess, on my end. I'm like, wait, I'm here doing this, and there obviously are people here that need interpreters. But
Right.
like, oh, they're fine. We got. So.
No, they're not. Well, and they may be perceiving it from a different perspective, is that, yes, they're fine, they can understand and communicate, they know how to operate whatever they're going to operate.
Yeah, they know enough
Exactly.
We're now introducing some new concepts and new ideas to them that may
Right,
not be
and-
Right.
as easily understood in English.
And if there are specific timelines, there are notifications that they have to get in that are time sensitive and things like that, you definitely need to try to have an interpreter or get somebody on the line that can help you convey that information to that individual. So,
Now, and there's a lot of resources that we have added at all three departments that you can use. I mean, when we contracted with those vendors that you can piggyback on, we, in essence, looked at all of these issues and say, we want vendors that are capable of providing not only language interpreters 24/7, but that there be also vendors who speak American Sign Language that also are available 24/7 through VRI, for example, video conferencing. And oftentimes, some of those vendors can do that through your iPhones. Technology has moved out so far that you can actually go into a home, have your iPhone, you can actually call your vendor and be able to put an American Sign Language interpreter on video and be able to communicate back and forth.
but whatever you do, the burden is on the employer, or in this case, on your agency to provide those all interpreters or interpreters in person to the customer without cost.
You could do it through a computer, laptop, you can do it through a tablet, and so forth. So there's different methods, and what you need to think is, again, it's going back to your policies, your procedures that you set up, and quite frankly, and I know that there's a lot to think about and so forth, but when you're developing your programs, you're applying for funding, you're applying for programs, you need to think about those things as well for your budget purposes, because what I keep hearing is that, well, we don't have the money. Well, don't give me that excuse. How long have you been required to do this? And how much time have you invested in developing the methods and processes that you should have developed from the beginning? That's always 50 years that we've required this. Executive Order 13166 just came along to reinforce and clarify what we should have been doing all along. Not to say that the regulations were exceptionally clear either before then, because it did. And I recall in the early 70s when I finally got involved in all this mess, is that when I read the regulations and requiring what is it that the law requires for a county to provide, an interpreter. It wasn't very clear, and the thresholds were pretty high, so nobody had to provide any language interpreters or whatnot. Not only that, folks, but I keep saying is that we have trained our LEP groups across the board. We have trained them very well to bring in their own interpreters. I still hear every place that I go, oh, we don't need them. They always bring their interpreters. We have posters that inform them. Where are they?
And when
In places that people can't even see them. So it's thinking about all those little things that, and I know it's very difficult. Believe me, I was in your situation when I had to write proposals and think about all this and how to administer and, where do I provide the services and so forth. I mean, I've been there. So I understand those things, but I want to make certain that you will know and understand is that it becomes from the very beginning in terms of the things that you need to include as the thought processes and what needs to be budgeted and so forth. And you'll understand a little bit.
Well, also, when you need to provide that information and you don't provide it with your own staff, there is a possibility that information is not translated literally so that person can understand it. Because if they have a relative or a child that understand a dialect from where they come from, that may not be exactly the meaning. So they may translate it incorrectly. And then if a case is brought, then your liability is higher. So it's always better to have your own interpreter if possible.
And I'll talk, we'll end up talking more about this in my other slides. Meaningful accessibility. What are we talking about meaningful accessibility? Well, obviously, Section 504 of the Rehabilitation Act, the Americans with Disability Act, and all of the requirements under those particular acts, and also when you couple in Title VI and the limited English proficiency requirements, require us to ensure that we're providing equal access, equal opportunity in a meaningful fashion. And what I was going to say here is that when you look at meaningful access, whether you're having meaningful access to your programs, to your activities, to your services, and to your facilities, whatever we require our participants to use ought to be accessible, needs to be accessible, whether it be if you're using computers, if you're using your website, if you're telling people go to our website, download our web application, or apply online and so forth, guess what? That also has to be accessible. There are different checklists that you can use to determine whether those your internet, your information technology, and so forth is accessible. Whether you're buying equipment, there is a checklist that you can use. Our monitoring instrument that we sort of modified already for equal opportunity officers to use in doing your own to do your own assessments, and that's the same tool that I use to monitor you for civil rights compliance. Does have a checklist that you can use by your purchasing person, that when they're purchasing new equipment, new phones, to ensure that it is compliant with Section 508. We make reference to, there are certain checklists that you're asked to complete. We ask you, and we'll talk a little bit about that. But for example, Section 188, disability checklist, if you take a look at that, it's very broad. It asks very broad questions. Questions that probably you can answer yes or no, but oftentimes takes a little bit more thinking. But if you're not doing sort of a real needs assessment in terms of going through your facilities and so forth, because at any time things tend to change. If you're not 100% in that particular office, staff move things around. Protruding objects and pathways, doors that are locked, signs that are taken down, posters and so forth, so that it requires you to look on a yearly basis and go through the process and really determine whether you're truly accessible. And that's just for physical accessibility, but you should also be checking your internet and so forth, and your policies, your procedures, and methods of how you administer things or your services. That's actually ensuring that meaningful access. So when you look at yourself, your programs, your facilities can actually be utilized by individuals with disabilities. In fact, I would recommend, and I recommend everywhere that I go, is that part of your annual assessment and so forth, you may want to have an advisory citizens group, persons with disabilities, that can come into your centers and say, can you actually utilize our services? There are folks, Centers for Independence may be able to help you find some folks. There's certainly a lot of groups that will advocate on disabilities and so forth that would be more than glad to help you do those things, because they know that if they help you be totally accessible, they don't have to worry about their clients coming in, and the same thing with language, for example. We need to make sure that we're proactively telling people, you know what? You don't have to bring your family or your friend to interpret for you. We will provide you an interpreter here. If we can't provide you a face-to-face interpreter, we'll provide you a line. We have a language line, or we have bilingual staff. Whatever methods you've developed. But we need to proactively let people know, because we do see families, we do see individuals bringing minor children and so forth to interpret.
And one thing to stress with trying to educate a customer who wants to bring a family member, let them know that, if this is real private and personal, that they may not want everybody knowing this. And if they have an interpreter or a family member, you may want to get a release from them, a signed release saying that an interpreter was offered but refused. Because at any time you're accused of breaching confidentiality of one's privacy, then you have that on file.
Individual private right of action. Consequences. The Supreme Court has established that individuals have an implied right of action under Title VI and Title IX and Section 504. The courts have stated that it has no doubt that Congress understood that Title VI as authorizing and implement private rights of actions for victims of illegal discrimination. Couple of cases I just want to mention: Cannon versus University of Chicago. That was a case that dealt with Title IX, but it specifically provided that that wording that did describe that under Title IX, an individual did have a right to private action. In addition, several courts of appeals have also held that plaintiffs have the private right of action to enforce the disparate impact, your methods of administration, any adverse impact that certain groups are having in your communities because they're not being served. The regulations, anyways, the Supreme Court has also ruled that monetary damages are available remedies in private rights of actions brought to enforce Title IX for alleging intentional violations, as well as Title VI and Section 504. If you can refer to your handout, then the heading should be Jury Awards. There should be one there. Sometimes folks that do not understand oftentimes end up paying. And guess what? What does it mean to a funded recipient? Well, if you think that your liability insurance covers that cost, you're totally wrong. That may come out of your own pocket. So I hope folks are saving in a saving account just in case. So even an LEP individual could go to court, go to federal court, and may be granted damages, especially if they succeed in proving intentional discrimination or even unintentional discrimination. So we want to make sure that we get ahead of this and make sure that you're not placed in any kind of a liability, or that you place us in a liability situation either. Because if one of your staff discriminates, that means that you discriminate. And if you discriminate, that means that we're discriminating, and on down the line. So we're all in it together, and we just want to make sure that you understand the implications and so forth. I don't know if you knew this, or how it affects and the importance of all this. Do we want to take a 10-minute break?
Yes.
And I think we need some coffee.
Be right back.
So you didn't.
Here. But I'm going to try to see if we can get it restarted. There we go. Wasn't too difficult to figure it out. Oh, but it's not displaying.
I love snow. The sooner we get it, the better.
I didn't know.
The sooner we get snow, the better.
I had a feeling it was coming, but I didn't know that it was already planned.
Yay, snow.
Good choice, because I didn't.
I love snow. Get out my big old snow blower.
Well, come by my house anytime you'd like. Get your winter on. I hope not. It's
Interesting.
supposed to be only 32
A
degrees.
lot of changes.
We got a little bit outside.
Oh my
going on.
God.
I mean, they're part-time still. Yeah, December 31st, he's talking about. It'll be a new crew.
All right.
Again.
I hate the gray period in between, you know. Give me- As soon as
Heard
it's
about an
cold,
Mine is
initiative
too.
that's
as soon
working
as it's
really well
cold,
with
let's have
Valley.
snow. Doesn't make any sense.
If you
Something to
tap
do with the Spanish Chamber of
laptops,
Commerce.
I think she said it should bring back your
So I'm hoping to
Snow and snow
talk to you
and
about
snow.
that because they're
But
coming
if
down.
it's gonna be gray and cold, you may as well have snow.
So, hoping to get your,
I'm still enjoying my month.
Doing it.
she said just tap on whatever you're using
Yeah, and that's.
under
oh, good.
Climate change gonna
or
flood the
computer.
eastern seaboard, but what do we care that half of New York will be underwater?
No. I'm sure.
Here,
Yeah, I heard a couple inches of snow in the southern part
She
of the
said,
Gulf.
what are we
there's
using?
snow coming, but yeah, I think it's coming from south to north.
We're recording
Where
now.
we go?
But Paul, what led you to
I'm
this
not sure
terrible-
whether it was PVR or
Not a terrible.
VCR.
I just didn't take him any longer.
Yeah, let me just.
Unrelenting.
Well, that's even crazier than
I just
asking
threw
for
in the
snow.
My sister happens to be, so it stops ringing.
Well, I hope you get somebody good.
I don't know how. I don't know how to use this thing. Let's not be crazy.
The level of partnership going.
Well, we're all hoping we can, raise the level with this next source.
Yeah, we'll see. I'll shoot.
Yeah, we
I'll
are.
go for
But I don't know,
Pardon?
I'll go for shooting
or would
you,
it be the camera?
because you're still stuck with me on my.
Hey, Barbie. So if they have their presentation on the
7 years
computer that
yet,
Jill
then we'll
usually
see.
does, what would we select? Because we're selecting laptop and it's not working.
I'm 65 already. I'll be 66 next year.
DVD, VCR.
I'm hoping I can do this till
laptop,
7,
camera.
we'll see.
And like I told the board, if I was 10 years younger, I think there's so much opportunity, and so much to be done.
Just a
but
guess.
Yeah.
I'm at a point where I'm
They're
going
doing
to
the
see
same,
it all.
they're talking.
It's better than
Yep.
to turn it over to somebody else.
I have a big mortgage yet, so I'm stuck regardless. 4 major home renovations did me in.
I thought you were going to say 4 major homes.
No,
Yeah, and that's what I thought it was going to.
four
Never
major home renovations.
Yep, got it.
I've been in
All right,
the same
you're on.
place for many years.
Okay, bye.
I hate moving.
Which if you spell it.
Okay,
Back in business.
let's get going.
Let's get going.
Rock and roll.
Here we go.
I like to do it.
Give me more equal opportunity.
User, right? I heard. And then there's another in between. The one that
All right, we're going to get into the specific areas of responsibility for the various individuals that are responsible for civil rights compliance.
Good.
Overall responsibility for equal opportunity civil rights compliance falls on the executive director, agency head, CEO, whichever you name that individual. That individual has overall responsibility to ensure that there's an effective civil rights compliance program for their particular agency. Whomever has authority to sign contracts for organizations is the person we hold accountable for overall compliance. The agency head or CEO may designate a responsible equal opportunity coordinator or a limited English proficiency coordinator, a complaint coordinator, or in the case of a job center, it also includes a job center complaint coordinator, which is a little bit different than an equal opportunity coordinator. Some agencies, and not necessarily in the job center, but some agencies do refer to their program complaint as their program complaint coordinator, but it's a little bit different than a job center complaint coordinator. So I want to make sure that I address this issue because I know that there's a lot of confusion as it relates to those three possible individuals who deal with different types of complaints. Agency heads. You designate the civil rights compliance staff functions, meaning that you have to designate somebody that provides, that is the equal opportunity coordinator. You adopt policies, procedures as needed. That's all part of the functions that you do in any case as an executive director. Ensure that the equal opportunity officer is identified, the identity is provided, that it appears in all internal and external communications about the recipient's non-discrimination and equal opportunity program. So it requires that not only websites, but brochures that you may have anytime that you advertise in the paper, and if you're inviting individuals to apply or so far, you want to make sure that the identity of that individual is included, telephone numbers, TTY, or how to get a hold of them, and pretty much, especially if that equal opportunity officer is going to be in charge of providing the different types of accommodations to individuals. That's why it's so important that you display that information. But also that you're supervising the equal opportunity officer to ensure that the annual, all of the responsibilities that are placed on the equal opportunity coordinator are actually being carried out on at least on a routine basis or at least a yearly basis. Again, ensure that staff are monitoring, implementing all of the internal CRC plan requirements, annual evaluations, and then obviously overseeing the civil rights compliance of subcontractors and vendors. So all of that falls on the executive director, but is oftentimes assigned to the equal opportunity officer or coordinator. The Equal Opportunity Coordinator, or EOC, is the point person for making sure that civil rights compliance programs are implemented as prescribed by the agency's Civil Rights Compliance Plan. Now, when we refer to Civil Rights Compliance Plan, that's mostly language that we tend to use for HHS, programs for USDA, and so forth. When we're talking about WIOA, because Department of Labor requires the state of Wisconsin to submit a method of administration in terms of how we're going to ensure that our subcontractors are meeting the civil rights compliance requirements, as well as the state of Wisconsin, or DWD, how we're going to meet our civil rights compliance requirements. And that's referred to as the method of administration. That's our version of the Civil Rights Compliance Plan. And in fact, the regulations, the way that I interpret it, does somewhat require local workforce development boards to develop your own methods of administration, which is that Civil Rights Compliance Plan. Now, I know that in some instances, some workforce development boards are using, for example, the Civil Rights Compliance template, the instructions, and so forth that were put out by HHS, the Division of Children and Families, and DWD. And to use that plan it's good because it meets most of the requirements. The only thing that it does not meet is the specific requirements in terms of equal opportunity statements that must be made, and a lot of it is because of differences in the target group population that are covered. It became very, very evident, and I'll use Southeast Workforce Development Board as an example, because it's a county, and certainly the county is allowed to use the instructions and the plan because the county administers the WIOA program. It is actually the county. The county there is the one-stop operator as well as the recipient. And it's very unique because, for example, Racine County has their own workforce development board, and so does the Walworth County. But because they're county, they can use those statements. The only problem was that, yeah, it's good and so forth, but WIOA requires very specific wording that be posted, that your statement be included, and that those protected groups be included in that statement. So what we suggested to Kenosha and Racine is that why don't we incorporate some of the protected groups, because most of the groups are already covered in there: race, color, disability, age, religion, and so forth, political affiliation, and because political affiliation is covered by DOL. Political affiliation is protected under USDA programs, but it isn't protected under HHS programs. So oftentimes we have to cluster it in all of the various protected groups and statements for counties because they were administering both HHS and USDA programs. The only thing that we did not include was the specifics under the WIA, and the reason was that because DOL requires us to have our own method of administration, and it requires the workforce development boards to follow that method of administration with very specific language. However, and I know that in the future you have programs that are operating under your one-stop center, some that also operate USDA programs, FSETs, others that operate W-2. They're also subcontractors of you, and they're in the same. They're in your one-stop centers as well, operating there. They're also required to post their own equal opportunity policies, their statements, and so forth. So you may see probably different postings that they're required to post, but then we're also required to post our own. If it's a unified, like a county that's doing everything, then it may be possible to incorporate all that protected groups and still be in compliance. And that really would probably be the best way and approach. Now, mind you that when we provide you templates, it is templates that we recommend that you use, the wording that you use, and that you incorporate that language into your, do your own letterhead, because we want you to display that, it is Bay Area Workforce Development Board that is, and, does not discriminate on the basis and so forth, and Fox Valley and so forth. You have to have those statements, and then, whoever you're subcontracting with also you have to ensure that they also have those kinds of statements and they're posted and so forth. And then again, they're posted in the languages of the LEP groups in your specific area. Again, that meet that particular threshold of, and then I'll go into it a little bit under the discussion of the LEP responsibilities. I'll cover the LEP stuff. But again, your equal opportunity officer, he is the designated person that deals with discrimination complaints, as well as ensuring that they implement all of the requirements. And in Doug's situation, he is responsible for ensuring that not only WIOA, but also the human services part of it is covered as well. So his head is a little bit much larger than, not your head, but your sombrero is certainly pretty big as opposed to somebody else that has a much smaller agency. And one size doesn't fit all, okay? I mean, it depends on the size of your organization, whether you can designate both an equal opportunity officer as well as a limited English proficiency coordinator. Again, as you can see, dissemination of policies, internal customer residents, patients, services providers, and other partners. Conduct annual CRC self-evaluations, programs and reports directly to the head agency, plans and executes EO and LEP functions together with the LEPC if, again, it's a large enough organization where you have one, facilitate CRC staff training and assesses staff training needs. So it's this ongoing things that need to occur on a yearly basis or on a periodic basis. Just one thing that you may want to, as the executive directors, is ensure that you are covering and are putting in your staff trainings, not staff trainings, but your staff meetings and so forth, that you are covering some equal opportunity issues throughout the year, whether you do it on an annual basis or whether you do it periodically. Ensure that you do have them listed in your agenda and or addressing your minutes, because oftentimes we will, if we monitor you and we ask for, how often have you addressed equal opportunity issues, you can provide the documentation that, yes, you have been providing that information periodically, or you've been discussing it, or that you've done training with staff, for example. A lot more other responsibilities include drafting memorandums of understanding or plans, monitoring agencies' EO compliance, may help handle complaints, facilitate provision of sign language interpreters and other accommodations, monitor data collection, maintains equal opportunity files, both confidential in a confidential manner, and liaison between the community and the funding sources. And it could be with our office, and it also may be directly with the Department of Labor, for example, the Civil Rights Center, or could even be HHS, Office of Civil Rights, or the Office of Civil Rights and USDA, depending on the programs that you also administer. Very specific language, and I know that you can't see it, and I apologize. I should have made copies for handouts for you. This is the official Equal Opportunity is the Law statement that should be posted at all workforce development centers, job centers, affiliated sites, any place that you administer programs or services. If you see the language, it has very specific mentions to the various targeted groups, includes U.S. citizenship and so forth. If you're an HHS funded program or USDA, you may be able to comply with those kinds of statements if you use the DHS, DCF templates, especially Appendix D that is provided in that template for the civil rights compliance requirements. It's an equal opportunity and employment and service delivery statement. It is a template. You could use it and just insert the agency's name. But we would recommend that you use the wording and put it on your own letterhead, because you want the clients, participants, or customers to know that it's your agency, and then who you can contact in that particular agency if they have an issue with civil rights concerns. You could also use the Appendices E. Equal opportunity in employment and service delivery statements from the Department of Agriculture, FNS, and Human Services. Again, because USDA provides more protections under different other kinds of groups, they want to make sure that their statement is included. So both HHS and USDA at the federal level came to an agreement and said, we need this particular statement, especially for agencies that operate both HHS and USDA programs. So now what we need to do is sort of just build in the DOL part of it for those agencies that deal with all three federal agency programs. Does that make sense? Here's the ones that I was just talking about. And then Appendices H is your limited English proficiency policy statement. I would encourage everyone to use the language there included in your letterhead. The limited English proficiency policy statement is very, it can be applied to all programs. All LEP requirements are pretty much the same. So the statement can be applied both to the HHS programs as well as USDA as well as DOL programs. It's just indicating that, your agency will comply and provide access to people with limited English proficiency. And then Appendix I, service delivery and employment discrimination complaints. That is, that template has both the instructions as to how to file the complaint, where to file it. And for example, it does provide different options. If you're a participant trying to file a complaint with USDA, provides wording in terms of where you can file that complaint at the state level, local, state, or federal level, as well as if it's an HHS program where you can file in those federal agencies as well. It includes our addresses as well. But for WIOA, again, WIOA has a very specific complaint form that DOL wants us to use, and I believe right now I haven't updated it, but it's pretty much the same. It just says WIA complaint, and it should be available to everyone that even through our website. But you should be able to utilize that particular complaint, and then again, you need to take a look at the wording in your complaint policies and procedures.
When will that be updated, David? So it says WIOA.
Oh, well, as soon as I catch up with all of my reports, and I can concentrate on updating my website, definitely.
18 to 20 months.
Probably the next couple of months.
Okay.
I will get to it.
Having that available to download is very useful.
There's a lot of, right now there's a lot of information that's there that you can download, but there's a couple of things that I do need to update that I just have not been able to. I've hit the ground running and I'm still running and catching up. But I do promise that we will do that. Before I left DHS, I left them with everything in there that they needed to do. So now they don't even worry about it.
Okay.
But they still send me all the questions.
that I got DHS questions for about 2 years after I left, so you've got a while.
I'm sorry?
That I got DHS questions for a couple years after I left there. So.
Well, Don knows DHS.
They still haven't.
Let them get their own.
Even staff at DHS probably don't know that you're gone.
The ghost of Corey.
Oh, I know. Limited English Proficiency Coordinator. Again, develops and monitors and implements policies, procedures as it relates to language, oral language assistance, written translation of vital documents, ensure meaningful access to provide services and activities by LEP customers, ensures data collection of LEP customer language needs, and analyze customer service language needs. Now, not every agency is large enough to have both an equal opportunity and LEP coordinator. So it is permissible to have one designated individual deal with both. And then oftentimes it could be the equal opportunity officer that has to ensure that these things are carried out. What is their official responsibilities? How do they meet their official responsibilities? How do you meet your section or Executive Order 13136? Wait a minute. There we go. All right. Executive Order 13166 does not establish new requirements or obligations. It simply provides additional clarification and recommitment to Title VI protected under national origin discrimination. Recipients are required to take reasonable steps to ensure meaningful access to individuals who are LEP. So how do we do that? How do we ensure, and how does that equal opportunity coordinator ensures that there is limited English proficiency accessibility? Well, the law says that you have to provide it. The guidance provides you the various descriptions in terms and methods of how you can provide meaningful access and accurate, meaningful communication. The first step in determining what is your obligation as a funded recipient is to look at the number or proportion of LEP groups or individuals that are living in your service delivery area, which are likely to be encountered by your programs. And again, you look at program, you look at services, and you look at your activities. Because you're administering different programs, you're going to have different individuals that may qualify or may not necessarily qualify, so you may not frequently see them, you may not see them at all. So every program, every program that has a different eligibility has different connotations here, or it has different requirements, because if they're not frequently seeing them in those particular programs, then, and if they do not, they're not represented in the population, you may not necessarily have to translate a vital document.
And whether you have to translate it or not, if you have just one, you need to make sure that you notice the public of the need to ask for the information, that they can ask for it in their language if they feel they need it.
So you look at what is the proportion, what is the frequency that you're seeing in individual particular language groups, and then you also need to take a look at the nature and importance of your particular program, the activities or services as provided by the programs to the people and to their lives. Give you an example. I guess the only example that comes to mind, for example, to sort of bring up what is the importance of the individual's program. If I was hungry and I wanted to apply for food share, would that be a program that is of importance and would be significant to my livelihood? And if I didn't get the services, if I didn't know or understand, that could be an impediment. That could be a barrier for me to participate, especially if you're not providing that services. So to me, as an individual with need, would be very, very important. So you need to look at the other thing is emergency room, for example. If a Spanish speaker came in or a Somalian or other speaker came to the emergency room and there was nobody there that could speak that language and it was a vital emergency, what do you think? Don't you think that accessibility would be very, very important? So sometimes we need to look at, how important is that particular program or services to them, rather than us looking at it from, we don't have the money or so forth. How do we actually provide the services? Those are the things that we really need to think about. The fourth factor that you also consider in analyzing and determining what is your agency obligation is the resources available to you as a grantee and the cost. The guidance provides flexibility, some flexibility, but what it does say is that you have to provide some means, a method of providing the accessibility. You have to provide equal access to those particular individuals. Here's vital documents. One size does not meet all. However, if you're doing the following, then it may be that you could be within safe harbor. Now, looking at it from a discriminatory perspective, you may not necessarily be discriminating if you're not within this particular safe harbor. What we tend to take a look at is the entire circumstances in terms of what are you doing, how are you doing it, and so forth. So it isn't just the fact that if you're meeting that particular threshold and you're not doing it, do you have other policies, procedures that have that same effect of providing the access? But in any case, translation of vital documents when an entity service delivery area reaches 5% or 1,000 of the LEV customers, whichever is less, per language group, you must translate vital documents. And when you take a look at that, if you're seeing them in such frequency, then it may be more cost-effective to translate the information versus having to pay an interpreter to do so. But if you happen to have staff to provide those particular services in their languages, then it may be even more beneficial as well. So there's methods. You either translate it, you do it through some other means, through verbally translate that information to that individual. That is also acceptable. It doesn't always mean that you always have to translate all your documents, but it's the methods that you develop to provide that accessibility. Notices must be provided to LEP customers that represent about 50 or less individuals. And again, you have to provide some kind of a statement to them. That's why we developed this very large you have a right to an interpreter poster to ensure that everybody complies with that, because we know that a lot of the counties, a lot of areas don't have the largest populations to then translate. But we still are meeting the requirements because we've got that statement that says we can provide that information if you ask for it. What we need to make sure is that we're able to provide that services at the time when it's needed.
So 50 or fewer, so if one individual comes in with a very unique language, okay.
You have to notice you have to make sure that you find a way to post that statement that says you have the right to vital information, vital document, or vital information.
How do we even anticipate something like that?
Well, you can't anticipate it all the time, but once they come through your door,
Okay,
you know that they're there.
okay.
And so it's the number of people in your service area. And notice I said the number of people in your service area who might be LEP, not necessarily the number of people that you serve.
Right.
Because they may be in your service area, and for whatever reason, outreach or otherwise,
Right.
you may not be getting to them. But a safe harbor thing would be to look at the statistics and stuff that we
Right.
provide to you on the
Those-
website.
Those we could anticipate. I'm just reacting to the 50 or fewer statement
Yeah,
that
so,
could really make it weird.
right, but aside from that, some people think, okay, they haven't come through our doors, we haven't served them in all this time.
Right.
But if we see that they
Okay.
are here in the county, even though they haven't come through your doors, and they're identifying themselves based on the census and the American Community Survey,
Then anticipate it. Okay,
then
that
Yeah.
makes sense.
they may be there.
Okay.
Yeah.
I've got a similar question looking at the bullet point right above that, where it talks about the 5% of an LEP customers, 5% or 1,000 LEP customers. Customers would imply these are people who are coming through the door then.
Not necessarily.
That's
It includes those, but it includes those that are likely eligible
Okay,
and are likely to be encountered because they're potentially eligible for your program. The fact that they may not be coming in because we may not be outreaching to their communities, we may not be providing that information to their communities saying, you know, you could be eligible for our WIA program. And we're not informing them, they may not be coming in. Or the fact that they may not know that, you know, even if I'm documented, okay, that I can still come in to your center and at least utilize perhaps your computer to do my own job search, as long as you're not referring, as long as your staff is not referring, actively referring undocumented workers to employers, you know, they have a right to come in and utilize our services. They don't have, the law requires us not to make sure that we're not including them in the WIA program because WIA has a very specific requirement that the individual be a U.S. citizen, legal permanent resident, or work authorized.
so for this slide, the term customer, we should really
That's a broad.
think about
Very
it
broad.
as eligible participant.
Anybody out there in your community. Part of your 4-factor analysis is looking at the landscape. Who's there? Who may we likely encounter? Once we identify them, then we can anticipate and say, you know what? My current vendor does not provide an interpreter in certain language, and we have that language represented in our area. Perhaps I need to look at a different vendor that does have those kinds of interpreters that I can utilize or that I may be able to utilize when there is a need. So a lot of it is thinking about this in terms of who are they, what is it that I need to be prepared for, and how do I provide it? How do I provide it in a cost-effective manner? What makes more sense, and what can you utilize there locally? So it's very unique. It's very unique to each individual agency because, you know, the same requirement applies to your subcontractors. And so they need to also look at it from their perspective. What is it that they're doing? How are they doing it? Who does it affect? Who are they likely to encounter? And those are the same methods they have to also develop to ensure that they're providing meaningful access and meaningful communication. Does that make sense?
Yep.
Who are competent interpreters? I think we talked a little bit about that before. Well, let me just say, yeah, I mean, we talked about the 4 factors and the various methods that you can provide equal access, equal opportunity. But again, also look at your technology, look at other means that you may want to institute. And by golly, every single job center that I've been to are technologically connected. Let me tell you. You got video conferencing, you got all kinds of neat little tools that you use because you're in a very rural area. Well, guess what? You could use that for your interpreters as well with your vendors, because we do have vendors that have that capability to provide VRI or VRS services. So that's another option that you also need to take a look and put into your tool of bags, or your bag of tools, I should say. Interpreters can be your own bilingual staff in English and in the second language. But you need to make sure that they're linguistically and culturally competent. Because oftentimes there's different colloquial words or different meanings and so forth, even within the same Spanish language. And let's face it, it's pretty white and so forth. But there's differences in the meaning of words and so forth and how they're used in different countries. So you want to make sure that they're linguistically first, that they're competent in terms of both languages, and to ensure that that they know and can interpret effectively both legal and the technical terminology that we tend to use. So a lot of it is ensuring that they're fully competent in that respect, but that whoever they're going to translate for, that they know and understand also some of their culture as well. Those things are very important. Who may not interpret? Minor children, forget it. Don't ever do it. And that would include all the way up to 18. Quite frankly, even those that speak English here are young kids, don't have a command of either language. And oftentimes what may end up occurring is miscommunication. So you always want to make sure that whoever is going to be the translating is providing accurate and meaningful communication. Now, I would avoid using family members or friends. We strongly recommend that, and that's why we recommend that you always have your own interpreters. Even if the individuals, the customer says, you know what, I want to use my family member to interpret for me. You know what, we have to give them that option and let them do that, but caution them and say that doing so may there may be miscommunication if they don't know the terms and terminology of the information we're going to share with you or talk about. So it's always good that you always bring somebody else to ensure that there's accurate communication occurring, accurate and meaningful communication that they really understand. Because most of the time, you're dealing with individuals that may know a little bit of English, just enough to get themselves in major trouble.
And again, if they insist, have them to sign a waiver or acknowledging that the service was offered. So,
hence, what I'm saying is that try to tell your receptionist, be proactive. If you're seeing this happening, let them know is that, for future, you may want to do that, this time, but for the future, we'll be more than glad to provide you an interpreter. Just let us know. We can certainly accommodate your need, but give us the information, let us know, or when you come in, let me know that you need an interpreter in such languages, because we have the policies, we have the systems, we have the methods of providing that services to you. And like I said, I think we've trained. I mean, when I was, I won't even say a young buck, as an advocate, working with migrant seasonal farm workers and advocating on their behalf, trying to get them services from the counties. Oh my God. Yeah. It is, we've come a major long way from what we saw in the 70s. What I saw in the 70s working out in the field. Yeah. And having to fight tooth and nail for services that they were eligible for, they were entitled to. But weren't being provided, didn't want to be provided, and so forth. All of the stereotypes you would find. Things are starting to change.
Is there anything embedded in the law around communicating with people who are illiterate?
Communicating with people that are illiterate.
In other words, a poster doesn't do me any good because I can't read.
Absolutely.
So is there anything embedded in the law about that situation?
Yes.
Okay.
It's called an accommodation.
Okay. So that's treated as a disability.
It's not necessarily it's not necessarily a disability.
Mm-hmm.
It is the fact that they can't communicate.
Okay.
It's a barrier. So
It's a barrier.
any obvious barrier, whether it's caused from a brain injury or just delayed growth,
Or just didn't go to school.
Yep.
and you recognize it, then
You have to
you're obliged to try to remedy that.
If they're eligible, if they're protected
Thank you.
by federal laws, we must provide. And the method would be we'll read the information to that individual
A verbal. Okay. Thank
and
you.
making sure that they understand.
Thank you.
Mhm.
But it is on them to, I mean, if they're, some people you talk to, you can't tell that there's a problem.
Right?
So, I mean, in that case, it would be on the person to say, I'm going to need a little extra help with this.
Right.
I mean, we're just not supposed to know.
And, and you're right. I mean, you may not know it until they tell you, and at that time,
Yep.
but then because you're equal opportunity officer or you're, develop the policies, the procedures, and develop the resources for you to use, you have those means of responding to that particular need in one fashion or the other. This is the poster that we commissioned by the three departments, and it's very specifically says you have your rights to an interpreter. And that English statement at the top is translated into all of those various languages. So that actually meets the requirement of the less than 50 individuals in a language LEP group in your specific service area. So if you're posting it, prominently where people can see it and so far, that is the statement. That's covering you already under Safe Harbor. It is the translation of vital documents, then that becomes very important that you make sure that you are looking at that and you are making plans to translate vital information, vital documents into the languages. If you haven't done so yet, I mean, we recommend that your equal opportunity officer, if you have an LEP coordinator, sit together and talk about looking at all of your documents and determining what is vital and what's not vital. What is it something that we need to translate? Does it make sense? Is it cost effective for us to do it? Or can we just do it verbatim? Can we read and make sure that, there is some kind of coverage for our liability that says that, yes, this was read to them, and that they've signed and acknowledged that, yes, we provided the information according to what we're required to do by law.
And in full disclosure, the Russian, the last sentence, it's a bit off in the translation. We'll have that corrected in the next printing, but just so you are aware. But the meat of it, that whole long sentence, it is correct and accurate that somebody reading Russian should understand.
Complaint coordinator duties and responsibilities. If your agency has a complaint coordinator in addition to an equal opportunity coordinator, they're pretty much the same again. They have the responsibility for ensuring that policies, procedures about the complaint process are posted, that information is provided to individuals, that if there's a particular complaint If that complaint coordinator deals with program complaint issues, then that particular individual handles those. If it's a discrimination complaint, then those complaints need to be referred to the equal opportunity officer. The equal opportunity officer is the one that investigates discrimination complaints. Pretty much it's important to give yourself a timeline. A complaint that isn't addressed in a timely manner is equal to dismissing a complaint. Also identifying what laws, regulations, and rules may have been violated, who must be interviewed, what data to review and analyze, who is the alleged violator. Chronology of the events. Okay, making sure that balance interviews with objective data. Again, looks at the preponderance of the facts, finding any conclusions, and then recommend for corrective action. It must be discussed with agency heads. Ask a state to assist if necessary. So they could handle either EO or LEP complaints, depending again on your specific agency and whether you have that ability to do so. Okay. Again, post. Maintain complaint records. May be responsible for investigations and so forth. So it's a little bit it's a little bit different. I'll cover the Job Center Complaint Coordinator system in a little bit. But let's talk about complaints. Well, here, I want to discuss about 4 kinds of complaints. Program complaints. Again, program complaints are those complaints such as they didn't complete my information in time, so I didn't get paid, or I didn't whatever they may want to appeal because the caseworker or somebody said something and didn't get anything done. They're a little bit different than discrimination complaints. Under WIA, grievances have to be heard from people who filed grievances that are WIA participants. They have very specific timelines that must be met. And oftentimes they're a little bit different than discrimination complaints. Discrimination complaints, a complaint can be filed within 180 days from the day that the discrimination occurred. For grievances, for example, a grievance can be filed before the end of a year from the time that the grievance should occur. And then there's specific timelines that when either the executive director or the equal opportunity officer has to act and provide a decision, and then must provide appeal rights all the way up to the Department of Labor's level. And then there's also the apparent violations and apparent violations of job service and so forth complaints that also have to be have a totally different timeline as well. And have certain implications. So I'll talk a little bit about that, but I'm running and I'm going to try to speed this up. Complaint processes, again, ensuring that applicants, participants be given accurate and complete information on the complaint process and procedures. And I would suggest that I've seen some policies and procedures that you try to compilate all of the various processes and timelines, and sometimes what it comes out is very, very confusing. And my suggestion was that, for example, if you're dealing with grievances, WIOA grievances, that you spell out that grievance process and timelines separately, that from your discrimination complaints. And the reason for that is because if you take a look at it, if it looks somewhat confusing to me, what do you think it's going to look to the participants or the customers themselves? They're going to be totally confused. The reason I say that is because we want to make sure that we do not violate their due process rights for appeals as well. And oftentimes, if somebody, if somebody is not given discrimination complaints, you have 90 days in which to issue your determination, even whether it's at the local level or at my level or at DOL's level, well, they have 120 days. But we have to make sure that that participant, from the time that the complaint is filed, that he has appeal rights all the way up to the Department of Labor, and that it's done within 120 days or before 120 days, so that they can have an opportunity to make a decision. Grievances is a little bit different, and you'll see that in your other complaints, it also has a different timeline and so forth. And I'll talk a little bit about that when I come to the complaint coordinator system, Job Center complaint coordinator system. Discriminations may be examined from two perspectives: desperate treatment or desperate impact. Desperate treatment is that intentional discrimination, so we'll look at complaints specifically, whether it's intentional discrimination, if that's the claim. But we also could take a look at complaints about those policies, procedures that have had the effect of discrimination. So we tend to look at complaints from those two perspectives. And I'm not going to get too much into that because I think we discussed both intentional and unintentional discrimination. Standard of proof for discrimination complaints. It's the standard of proof in the investigation under Title VI, and similar non-discrimination statute is the preponderance of evidence. Again, procedures must consist of federal, state statutes, rules, regulations, and so forth. Again, looking at and ensuring that your procedures are not violating the due process, and ensure that those complaints are being dealt with in a timely fashion. The other one was that I didn't even touch was the employment discrimination complaints, and although you don't handle those, but you may, as an equal opportunity officer at the local level, the only time that you would deal with an employment type of a complaint would be, if you are engaging in on-the-job training, somebody is placed in an employer, or perhaps even in an apprenticeship type of a situation. That's when you do have jurisdiction over in looking at an employment issue. But otherwise, if it's somebody that's coming in from outside trying to file a complaint against employer X because they feel they were discriminated, we had nothing to do with the posting or the referral or whatnot. They want to file a discrimination complaint. Those kinds of complaints have to be filed either with the EOC or the Division of Equal Rights, who are the two agencies that have jurisdiction over all employment laws.
We do get calls about those kinds of things because we are the local.
Right.
And I always send them right to Equal Rights.
And Division of Equal Rights and EOC have an agreement, so they can sort of look at each other's complaints. And in fact, if somebody files a complaint with the Division of Equal Rights, and EOC may want to take a look at that complaint after the Division of Equal Rights, makes a decision. But they work hand in hand on those specific types of discrimination complaints.
David, just to make sure I've got that right then, so if there's a complaint of employment discrimination where the individual has not been a program participant, not an apprentice, not anybody that we worked with. The proper place for that is to the Equal Rights Division.
Yes.
If it's an employment type of complaint, yes.
Okay.
The ones we get most frequently, at least the ones I get most frequently, are he won't pay me.
Yep,
So it's a wage and hour dispute.
it's a wage and hour issue. Yeah, even our employees may be able to utilize EEOC or the Division of Equal Rights as well. It is.
Thank you.
Not too much. I think you get the gist of some of this, and you're actually able to read. The complaint processes, I mean, again, HHS discrimination complaints can be filed at the local, at the state, or at the federal level. Customers have that option. At USDA, they can also file pretty much with the feds directly. They can file with the state, whoever's administering the program, and at this particular state is DHS. With WIOA, again, they have the option to file at the federal, at my level, or at your local level. And we encourage people to try to utilize the local level first to try to resolve the issue. But they do have the option to file anywhere that they want to file their complaint. Oops, wrong one. DOL. Pretty much, it's also included in the equal opportunity is the law poster. It's where you file your complaints at the federal level with DOL. Department of Health and Human Services, you can file at the regional level in Chicago, or you can also file with the main office, the Office of Civil Rights in Washington, D.C. Your discrimination complaints, USDA, FNS. With the Office of Adjudication in Washington, D.C. My suggestion that if somebody wants to file a complaint at the state level, I'm not sure who is designated at DHS to deal with USDA complaints. I know that Jerry Grinshaw, there you go. Is in the office of the secretaries, but deals with constituent relations types of complaints, but I think he has been designated as a person to, quite frankly, I think what they need is an attorney there that actually can deal with the different types of complaints that come in through HHS. I'm not sure what they're going to do since I'm already gone.
He will refer them to the program areas to try to get them some relief, or if they need to go to fair hearing or something like that, tell them how to get there. But he's it for now. So that's Jerry Grimshaw, Grimshaww.
And then anyone can file a complaint with the Department of Justice as well. And it could be a complaint about HHS programs. It could be a complaint about USDA programs. It could be a complaint against us, and so forth. They could also go to the Department of Justice, and the Department of Justice would then work through the process to make sure that we resolve those issues. Yes, Mark.
Yeah, I just had a question. We have multiple agencies in our job center, our subcontractors and stuff. And for example, another agency has the FSET contract. And so if somebody has a complaint about FSET, would they come to me as the complaint coordinator, or would they have to go to, the agency that's in charge of that program, or would it go directly to state or federal?
You can give them that option as a job center complaint coordinator, and then we're stepping right into the next discussion here. And if you can bear me another 5 minutes or so, and I can go through it pretty quick. Yes, the answer would be since you're designated as a job center complaint coordinator, your functions, quite frankly, is to triage.
Okay.
Because there's different partners in your one-stop center. It could be about your agency, or it could be about the board. It could be about whoever's doing the FSET program. So what you do is you take that complaint, you help them write it if need be, then you refer that complaint to the designated person in that agency who deals with complaints.
Okay.
Oftentimes, those agencies are required to also have an equal opportunity officer or somebody designated to do those particular functions. So they get turned over to them. It is your responsibility to log in that particular complaint and then follow up on that complaint to ensure that it was dealt with. You don't necessarily have to get all the details in terms of what was the result of the complaint itself. What you want to do is you want to make sure it's saying, yes, we received it, we referred it, it was dealt with, and if you found the outcome, great. We want to record that particular process. But job centers are unique in the sense that under Wagner-Peiser requires that jobs, and especially the job services, who oftentimes take job orders from employers, and oftentimes deal with the labor market exchange, interstate clearance orders, recruitment orders that are placed by employers from another state. Give you a very good example that maybe help you drive it right down to the ground here. Migrant seasonal farm workers, state of Wisconsin employers that require migrant seasonal farm workers to come in and work during the season. They come to the Department of Workforce Development, Department of DWD and Job Service and place orders with Job Service. And we end up sending those job orders to another state, depending on where they want to recruit from, to post those particular job orders with the job centers down there as well. So they're interstate clearance orders. When you have migrant seasonal farm workers, there could be apparent violations. The state of Wisconsin has a migrant labor law that requires every migrant farm worker that's recruited from another state that they have to have a contract, a written contract that stipulates what are the wages, how many hours are they going to work, whether they're going to be provided housing, what are the types of accommodations, and so forth. So if they're recruited in, let's say, in Texas or even in Mexico, for example, they have to have a contract either at the time that they're contracted, when they go down to Texas or when they're going to job service down there, or at the time that they get here, they have to have some kind of a written contract. We have migrant housing inspectors, inspectors that go out and inspect migrant housing, but also inspect their contracts to ensure that they're complying with the law. If one of those complaints if somebody would file a complaint, then it would have to be dealt with, and it has to be dealt within about 5 days. I mean, if it's an employer if it's against the employer, then it has to be investigated with a certain period of time. And guess who has to investigate those complaints? It's the job service manager or director that has to investigate those types of complaints. It isn't the equal opportunity officer. It isn't the job center complaint coordinator's function to do that. Okay? Your function is to triage and make sure that those things are happening with the various agencies and so forth, including job service. And that's why we ask that you have a log and so forth. That's the extent of the duties of the job center complaint coordinator. But it is important that you know and understand the processes of all of the various complaints and systems that you're going to have to be dealing with. As we explained, you've got grievances. It could be that WIA participant comes to you and says, I want to file a grievance. Okay? So who do you file that? Who do you refer that grievance to? Is it the equal opportunity officer at the Workforce Development Board, or is it a different manager that deals with those particular grievances, or is it the executive director that deals with those grievances? It's ensuring that you know the processes and the timelines that need to occur to make sure that you get them to the right place and whoever's going to deal with those particular complaints. The rest of it, I think it's self-explanatory in my slides, and I'm not going to go further much because I think you understand that the Job Center Complaint Coordinator is unique to the job centers. Your functions are to triage, your functions are to record and so forth, not necessarily investigate those kinds of complaints, unless you're being designated or being given two sets of responsibilities as the Job Center Complaint Coordinator and also the Equal Opportunity Complaint Coordinator. So you need to know and understand at what times you put on what hat and take off the other one, and ensuring that the timelines are correct. So that's why I kind of want to make sure that we kind of look at things differently and make sure that we explain things very clearly to people so that they don't, that we make sure that we're not violating anybody's rights or any due processes.
Thank you.
And we really scratched the surface, folks. And that's why it took about 6-7 hours to cover all of the things, because before we did go into, for example, the adequacy of providing services to people with different types of disabilities. In fact, we provided a little bit more training in terms of how do you provide equal access from different perspectives, breaking the barriers for limited English proficiency and so forth. And this is a work in progress. We just started retooling. I just started retooling this. This material, this information has been around since about 2006 when we initially did training. That training for about 6-7 hours. But we know and understand that there's different needs for materials for you folks to do. Human services, it's a little bit of a different approach than workforce development boards. And there are other agencies. Not only that, but if you look at HHS and the enormous amount of providers that they contract with, which includes hospitals, includes Medicaid, medical assistance programs, includes doctors, clinics, and it also applies to them as well. And so they also have the same needs of meeting civil rights compliance requirements. And so training is also vital. So, I've been talking about developing different modules for different audiences to ensure that we're covering the right areas. And that's, folks, this takes time to really sit down and do, because I'm not going to do you any justice just to say, I have a lot of this in my head, but if you don't know what to present, I can give you slides and so forth, but if I don't give you notes and saying, here's some recommended points that you want to address and so forth, and then you certainly should add to that. Use this material, but then, you might want to add your own materials. Training, recommend policies, procedures, internal policies, procedures for your staff. Do it annually. Look at all your posting requirements and so forth. Look at that. What is means accessibility? How do you provide accommodations to different individuals? What is it that we're required to do? What is it that we have in place to ensure that we've got that information? Because when I've been conducting interviews with staff to get a baseline in terms of knowledge and so forth. And there's a lot of times that people don't know that there's policies, that there's procedures. And sometimes they get away with saying, oh, yeah, it's in the Drive G or whatever, it's in our policies and procedures. Okay, do you know? It's that yearly touching on some of those issues and some of those topics that you need to sort of do. And you don't need it to do them all at one time. You could space it out in a matter throughout the year. Maybe every quarter you bring in folks that talk about disabilities, and you've done a great job already. All around the state, there's been a lot of training on disability because of the Disability Employment Initiative Project. But how do you deal with the other populations? What is it that we need to know about cultural sensitivity and awareness? All of the other cultures that we have. Some offices have worked, like for example, at West Central at least. I was pretty impressed that they did hire somebody, 2 Somalian workers, one that's a receptionist, and boy, I can tell you that community in Barron County is very, very happy because there's over 300, 400 families that live there that work in the turkey factory. And quite frankly, a lot of those families that are coming in from the Twin Cities are relocating in Barron, and then there's a second migration that has occurred to Brown County. You were seeing with the inward migration of Somalis that came in a couple of years ago that it started. And it was started, why? Because of the housing authorities' Section 8 housing list was 6 months. Compared to some of the other states and some of the other communities that were there, was taking about 2 years or so before you could get up to the list for Section 8 housing vouchers. Well, Green Bay had a 6 month. Well, guess what? We saw a major influx of families moving in. And then we found out it was the reason why. And then everybody was going crazy, putting on panic buttons in caseworkers' offices because those women are too assertive. Oh, come on, please. They were get scared. It was a need for cultural sensitivity, cultural understanding in terms of why do they do these things. We can escalate a lot of the tensions and a lot of the fears if we just, spend some time and learn a little bit more about their particular communities.
I mean, we can de-escalate.
David, thank you. This has been very, very informative. And I appreciate the slides in particular, the slides in the latter part where we talked about language proficiency, where you were able to start identifying some of the things that we should be doing, were very, very helpful. Not that I'm complaining about the earlier slides, but I know that there's a lot of laws that you cited. It would be nice to have, similar slides that would kind of identify, and these are the big impacts. These are the things that you need to be watching for, because I couldn't write notes fast as you were talking, quite honestly. and even then, I don't anticipate I could ever know as much as what you know. And what we're looking to do is get that knowledge transfer.
Right, and the laws are just to ensure, I didn't cover them completely or anything. It's just there for your knowledge and saying those laws apply both to on unemployment as well as on a service, and which ones apply to what service delivery and so forth that you need to pay more attention to. I try to address some of the more kind of hot topics that are coming up. Sort of like the definition of sex now extending into all of the other categories that are protected and what we need to do and so forth. Some of the things that you really need to kind of pay attention to. But
and I apologize because I need to get back for another meeting this evening.
You make sure that they get the vote stamp?
Yeah.
I passed.
You passed it around? I'm not going to cover. I think we provided you the